Call the member for Heffron.
Mr Acting Speaker, the member for Liverpool and the Leader of the Opposition have indicated the Opposition's position to the Independent Commission Against Corruption Amendment Bill 2016, and I endorse their views. The member for Liverpool has proposed some amendments to that bill, and those amendments are to Clause 4 in Schedule 1, Clause 20 in Schedule 1 and Clause 6 in Schedule 2. And the effect of those amendments basically places the House in this position. If you reject the opposition amendments, then the government members are simply voting to sack Her Honour Justice Latham. And now that's the reality of the situation that the government has now placed itself in by the opposition amendments. Now, this is not the first time provisions contained in legislation have been inserted by the Parliament in an effort to remove statutory officers. In fact, in 1985, this Parliament carried the Local Courts Act, and in enactments and in decisions made in 1986, when stipendiary magistrates were abolished and magistrates were appointed and the local court was established, 5 magistrates were not appointed. It was the way in which the government of the day rid itself of troublesome magistrates that they could otherwise not get rid of. So that the provisions are not unique, but it has been 31 years since it has been last used. But effectively, the challenge has been thrown to the government by the opposition, and the government is now in a position where it will need to make a decision that effectively only has one result. Now, it is unfortunate that this provision has now distracted the Parliament's attention to a very comprehensive review undertaken by the Statutory Joint Committee. Now, the report that has been tabled several weeks ago, of which I made some observations only last Thursday, was a bipartisan report prepared in very difficult circumstances. The Joint Committee had considered extensive evidence, many very comprehensive submissions, and had private briefings, including one from the main architects of ICAC from 1989. Now, I just remarked in the House last week, and I say again, that I am extremely grateful for the assistance all the witnesses gave, all the people who made submissions, and from the private briefings that I received as a member of the committee. It is clear that the purpose of the Independent Commission Against Corruption is the same today as it was 27 years ago: to investigate and expose serious and systemic corruption in the public sector. I agree with the evidence, the briefings and the submissions made to the committee, and that is that the concept of serious corruption generally occurs in secret, conducted by persons of influence. And whilst on nearly all occasions that conduct is criminal, I accept that the prospect of obtaining admissible evidence by traditional law enforcement means is limited and at times not possible. As was put to us by the architects of ICAC for some 27 years ago, the nature of the corruption that ICAC was established to deal with would make it impossible to collect admissible evidence virtually, and that the ability to prosecute people for that criminal conduct would be very rare. And that was the mode of reasoning that ICAC was established 27 years ago. Now, as I pointed out to the House last week, and I say again in respect of this bill, I have come to consider this matter influenced by some very fundamental principles. And it's a pity that the Parliament doesn't consider these fundamental principles but has descended into a personality debate. And those principles are what I believe in, and not, as I said last week, academically. And that is that I fundamentally believe, and the House should believe, in the doctrine of separation of powers, the presumption of innocence, the proof of guilt being required beyond reasonable doubt. Now, those cornerstones are the principle of our democracy. And if you impede these principles with legislation, it is not just contrary to principle, but you risk bringing into disrepute the very arm of the executive that Parliament charges with the responsibility for administering the Act. And that is exactly what has happened in recent times with the Independent Commission Against Corruption. The attacks by the media on that organisation, but by a broad-ranging section of the media, which has in some quarters brought the organisation into criticism and focus, in my view, is that the Parliament has set up an organisation that has resulted in exposing that organisation to criticism. Now, I accept, because of the nature of serious corruption by the powerful, as has been evidenced in recent years by people from both major political parties, without these extraordinary powers, I suspect that conduct would not have been uncovered. So if Parliament wishes to even extend the Commission's investigative power, subject to proper balance, I would support it, and I would take no issue. The real issue and the controversy that plagues the Commission's activity has got to do, in my view, with the fact that Parliament has created not an investigative body to investigate and root out corruption, but it has established a hybrid model, as Mr McClintock SC told us, which is both investigative and determinative. And as soon as you give an organ of the executive government a determinative function, you bring in these concepts of procedural fairness and of natural justice. If the Commission did not have a determinative function, you wouldn't have to worry about 3 commissioners, you wouldn't have to worry about a procedural fairness. None of those issues would present itself. I joined with the committee's report to achieve a bipartisan result to achieve some level of procedural fairness. But I want to put on record that whilst the legislation wants to have a determinative function, that it is always going to leave itself open to criticism in relation to procedural fairness. Because, as I pointed out to the House last week, the Independent Commission Against Corruption is an organ of the executive branch of government. However, it is presided over by eminent jurists or eminent members of the bar. The presiding officer sits on a bench under the state's coat of arms. Counsel bow to presiding officers, and witnesses are called and cross-examined. It's given the appearance as if it operates like a judicial arm of government with determinative functions. But it is not the judicial arm. And the problems that it has run into recently, in my view, relate to that. Now, the general public, it is actually an organ of the executive government, and the general public will ultimately expect this organisation to operate fairly. And so one of the things that I asked the architects of ICAC 27 years ago, which I thought was quite fascinating, Mr Acting Speaker, can I have an extension of time, please?
The member for Heffron has requested an extension of time. Is the extension granted?
I asked him, with this hybrid model, how did you expect fairness to apply to the Commission? And his response was that he thought that fairness would apply by virtue of the bar rules. But it's pretty clear that that the bar rules were not applied. That issue has now been resolved by clauses 96 to 100 of the Legal Professional Uniform Conduct Barristers' Rules of 2015. So the problems that the architects of ICAC envisaged 27 years ago, that would have it operating with fairness, having all the principles of a Minister for Justice apply to counsel assisting, and having counsel assisting not giving interviews to the media and things of that nature, have all been rectified last year by the bar rules. So I question whether or not there is even the need for these procedural fairness guidelines. But as I said, I joined in respect of it. I told the House last week, and I tell the House again, I decided to achieve a bipartisan decision. I was prepared to go along with this recommendation of the three-commissioner model. The three-commissioner model was a submission made by the Premier's Department. Part of its justification was to retain what was because of to prevent agency capture. I said that last week there was no evidence of that. I was not a supporter of that particular model. In fact, if you take the determinative function away, there was really no need for it. But I did tell the House last week, and I say again, and it relates to the opposition's amendment, I do not accept the criticism of the ICAC officials who have been lawfully administering this legislation. The fact of the matter is this, and it's been one of the great failings of this Parliament over the last 27 years, and that is that the Parliament cannot tell a Commissioner of the Independent Commission Against Corruption to perform a function and exercise a discretion and then complain when they do so. And there is no point having eminent jurists preside over it and expecting eminent jurists not to follow the legislation, because that is what they will do and that's what they're trained to do. If this House is not happy with the way in which the Independent Commission Against Corruption undergoes its function, then it ought to look in a mirror and look at its legislation. And what has happened now, even with this legislation, is that there has been, again, no discussion about fundamental principle. The discussion has now occurred in relation to this commissioner, because clearly the government want the commissioner removed. I would have much rather had this House talk about principle, and so that this House can be aware of what it is doing in terms of the principle of the doctrine of separation of powers and the principles that need to be applied when you are going to give an organisation considerable power to root out corruption that you cannot root out by ordinary and traditional means. And for 27 years, members of both major political parties, in fear of being brandished soft on corruption, has failed to address these particular fundamental principles. Now, if you want an investigative organisation to root out corruption, then Parliament needs to see whether or not it is determinative. Because I'm telling you this, I question whether or not what you have recommended in this legislation in terms of establishing procedural fairness to a hybrid commission is going to achieve the objective you are seeking to achieve. Because you are going to open up this commission, irrespective of how it's constituted, to again litigious attacks that may well be successful, as you are imposing concepts of procedural fairness which you must impose to an organisation that is determinative. If the organisation is not determinative, you can increase its investigative power without procedural fairness. You don't need three commissioners to provide, for whatever purpose you want three commissioners to provide some balance. But at least have this discussion. Why, in one of the most important reviews in probably 27 years of an Act where for the first time ever there was a prospect of there being some bipartisan support, the discussion of principle has now got to whether or not the government wants to sack the Commissioner in a way in which it sacked magistrates 31 years ago.
Mr. Speaker.
I thank the member for